So here's the loaded question, one you'll probably not be able to answer. Do you think this will succeed?
Let me be blunt. I'm not in the habit of bringing cases that I don't think have a chance.
As the perfect dovetail to our video yesterday where we broke down prorogation, as well as the UK 2019 decision, we're pleased to introduce James Manson, who is one of the lead counsel lawyers in the court challenge to Justin Trudeau's recent prorogation of Parliament. James is no stranger to high-profile cases and fighting for what is right, as he is also counsel for the defense in the Freedom Convoy class action lawsuit.
Let's take a look. James, welcome to Northern Perspective. It's nice to have you here today.
Thanks for having me.
No problem. So, James, you are one of two counsels, I believe, that is working on this case. Maybe just give us a 30-second overview of who you are, how you got involved in cases like this, and what brings you to this case specifically.
Well, I was basically a general commercial litigator for a large part of my career. I've been a lawyer now for about 16 or 17 years. About 15 of those years, I was based in downtown Toronto, doing general work for law firms and private practice, usually fighting with companies about money and insurance things and very boring things like that. And in the midst of the COVID situation, I sort of woke up one morning and realized that I was really quite unhappy with the way that our government was behaving and all of the restrictions that had been put on us in terms of, restrictions on civil liberties and all of that, as I'm sure we all remember. And I basically said to myself, look, James, you've got some skills here. You've learned a lot about how to be a lawyer and how to run a case. It's time to do something else. It's time to do something different and to maybe try to push back against some of this restrictive stuff that's going on. So anyway, long story short, I reached out to people in the constitutional space, in the public interest civil liberties space. I found the JCCF. One thing led to another, and here I am.
And now you are taking on probably what may fast become one of the most famous cases in Canadian history in challenging prorogation. So how did that come about?
Well, I'm not sure it'll be the most important or the most famous case in history, but I appreciate that. But I'm not sure about that. But it is an important case. I will grant that. It came about simply by me reading a decision from the United Kingdom, from the UK. And that decision was released 5 years ago. The viewers may recall Prime Minister Boris Johnson, about 5 years ago, decided to prorogue Parliament in the UK. And that was in the context of the Brexit negotiations. As you guys recall, there was a 8-week window left for Parliament in the UK to come up with an agreement with the European Union in order to figure out how England and the UK were going to leave the EU. And if they couldn't, there was going to be what they called a hard exit with no agreement. It would have been very, very probably catastrophic for the economy and the social issues in terms of like what are the people supposed to do in the EU and in the UK. So people wanted to avoid that. But in any event, Boris Johnson decided that he would shut down Parliament. He would prorogue Parliament for 5 out of those 8 weeks leading up to the Brexit deadline. Ultimately, what happened was there was a challenge in the UK in the same vein as the challenge that we're bringing, here in Canada. And a couple of citizens of the UK challenged the Prime Minister's decision to advise, at that point it was the Queen, to prorogue Parliament. And ultimately, the UK Supreme Court decided 11 votes to 0, 11 to nothing, that the Prime Minister's advice was unlawful. And here's why. Basically, the Supreme Court said that if a if a prime minister wants to prorogue parliament, he or she needs to have what they call a reasonable justification to do that. You have to have a good reason. It can't just be because I want to. There's got to be something else. There's got to be some kind of reasonable explanation for doing so. And in that case, back in 2019, Prime Minister Johnson didn't give a reason. The advice he gave the Queen was private, and nobody knows what it was. And he never gave a public reason in terms of what of why. People were speculating, oh, this is because of Brexit, and you want to avoid facing the opposition in the House of Commons or whatever. But there wasn't actually a reason given, and so it was easy for the UK Supreme Court to find that there had been no reasonable explanation given because there wasn't any explanation given. So it was easy in the UK's case. What the UK was driving at, or the UK Supreme Court was driving at, was the notion of parliamentary accountability. Also the notion of parliamentary supremacy. These are two important principles that form part of the unwritten part of our Constitution. Just so the viewers understand, and this is going to get I don't want this to get too academic, right? But there are written parts of the Constitution written down in the actual text of the Constitution and the Charter of Rights. And there's also some unwritten parts which are codified through common law and also, understood as principles that people have to abide by. One of them is that Parliament is the supreme body, is the sovereign body, and what Parliament says goes. It's not just the government. The government is not the supreme body in the country. It's actually Parliament itself. And as the viewers may understand, when you've got a minority government like we do now, it's more important. It's even more important because the other opposition parties can get together and overrule what the government proposes. The government might say, we want to change this law whatever way. And if everybody else votes against them, then that doesn't happen. So parliamentary supremacy is a big deal. The UK Supreme Court, reaffirmed that. Then they talk about parliamentary accountability, and that's also very important. And what that means is that the Parliament has to be able to oversee and supervise the government. It has to be able to exercise that obligation. That's the whole point of parliamentary accountability. It's the reason Parliament exists, to be a check on the government, right? And so if you suspend Parliament, if you prorogue Parliament, you are interfering with Parliament's ability to do that job, right? If you just adjourn Parliament, the viewers may not understand proroguing is not the same as adjourning. Adjourning is simply a quick break for Christmas vacation or holiday vacation or whatever you want. But the committees are still functioning, and the business of government is still going on. All the bills that are before the House are still live when you come back. And so nothing really changes. It's just a bit of a break. Prorogation kills everything that's going on. The committees can't meet anymore. All the bills that are currently in the process of becoming law, they die, and they have to be reintroduced later. So everything grinds to a halt for as long as the prorogation takes effect. So anyway, prorogation is a very important tool, and it's often, commonplace. It's not really a problem to have prorogation in many ways. Sometimes you have the end of a natural legislative cycle, right? There's a speech from the throne, and the Governor General will give that speech. As we know, the government says, I want to have this law, that law, the other law. Here's our program. Isn't it great? Then they get to the end of that program, and there's nothing else to do. Well, they're going to have to then retool everything, go back to the cabinet departments, find new initiatives. Hey, what other laws do we want to pass? Are there any laws we want to amend or repeal or whatever? And there's a new direction outlined. And that's a legislative resetting, which is normal.
And
The
that's what Stephen
problem,
Harper did a couple times in his reign as well. And just to kind of expand on parliamentary supremacy that you brought up, it's such an important concept. And just for everybody watching, this is why Justin Trudeau and the Liberals could not break out of Parliament being seized because of parliamentary supremacy. The House had ordered the production of documents from the government related to the SDTC file to the RCMP unredacted. The government refused to do that, so a question of privilege was raised, and because of parliamentary supremacy, the government couldn't function because Parliament had ordered this production and they hadn't done that. It was the same back during the Winnipeg Lab document production, where they were ordered to produce that. The government refused and ended up taking the speaker to court. Just wanted to touch on that.
absolutely. To take it back to that UK case, the UK Supreme Court said parliamentary accountability is super important, and if you interfere with the ability of Parliament to do that oversight and supervisory role, that's a problem without reasonable justification. And so again, bringing it back to this case now, the viewers will want to know, okay, James, you've told us about the UK. How is that relevant here? Because it's not binding in the UK, it's a different country. Yes, of course. We will be asking the Canadian court, the federal court here, to adopt, not because it's binding, but because it makes good sense, because it's persuasive, to adopt the reasoning of the UK Supreme Court. Because our constitutions are supposed to be similar in principle. That's what our constitution says. It says that our constitution must be similar in principle to that of the UK, because of course of our shared history together. So anyway, we will be asking the court to adopt the rule that was laid out in this UK case. We will be suggesting that in this case, the Prime Minister's power to prorogue or advise the Governor General to prorogue must be limited by something. It cannot be unlimited. There's got to be some limit to that power. And what is the limit? Well, we will say there's got to be a reasonable justification. Now, it's possible that the court will not accept our argument, and they don't want to accept the UK's reasoning 100%. They might go partly there. They may modify it somehow for Canada. Who knows what the court will do? But I think the viewers should understand that regardless of whether or not we carry the day on the ultimate question in this case, the legal question, the constitutional question, is even perhaps more important. And that question is, what are the limits of a prime minister to suspend parliament for however long they choose? Are there limits? And if so, what are those limits? Because, this is an important issue. If prime ministers are going to be using this power to prorogue, to, avoid messy political issues, we need to know what those parameters are. I think all Canadians ought to be very concerned about that. And I'm not talking politically at the moment, right? I'm a lawyer, and I'm speaking to everybody here from a legal point of view, constitutional point of view. It doesn't matter that it's a Liberal prime minister at the moment versus a Conservative prime minister back in 2008. The principle remains the same. If Pierre Poilievre becomes prime minister in the next year and does something like this, we need to know also, was that okay? I understand that some people may be less angry if it's a Conservative than not. That's not my interest. My interest is the proper functioning of the Constitution and the executive, whoever they are. So ultimately, we're going to be asking the court to adopt that UK reasoning. Once we know what the parameters of that power are, whatever they may be, we will then ask the court to use those parameters and apply them to what the prime minister did in this case. And so now we're going to be talking about what are the justifications given to us by Prime Minister Trudeau on Monday. As I'm sure the viewers all know, he gave us basically two reasons on Monday. He gave us the reset reason, and he gave us the leadership race reason, right? So first of all, let's deal with the leadership race. I think my client's position, our position will be that that is not really a reasonable argument. You're talking about having a leadership race. That's an internal party matter. It's not a matter for the government. Remembering that the government is a collection of people who are ministers of the crown. They're not really, yes, they're part of a party, but they really don't wear that hat in the cabinet room. They wear ministerial hats in the cabinet. And so they are ministers of the crown. The idea of a leadership race for a party has really no bearing, in our argument anyway, on whether Parliament ought to be prorogued, and if so, for how long. It's not Canadians' problem, frankly, that the Liberal Party has a leadership issue going on right now. That shouldn't be something that Canadians should have to wait around for. So our argument will be that reason in and of itself is not reasonable. So then you've got the other reason, which is a reset. So we did not hear, at least that's what we're going to argue. We did not hear on Monday that the Prime Minister wanted to have a new legislative agenda. We didn't hear that he wanted to have a new cabinet, have a new speech from the throne, set out a new policy direction, or anything like that. We only heard that Parliament was dysfunctional and that there was a lot of acrimony going on and that there was, paralysis going on, things like that. And the temperature had to come down, in the Prime Minister's words. So our view, again, is that that's really not a reasonable justification. In our view, the reasonable justification simply isn't there. What would make more sense would be to have an election, of course. Would be, if you want to bring down the temperature of Parliament, call an election. Face a motion of non-confidence if that's what the opposition wants to do. And if there's an election, so be it. But just because things are getting a bit bumpy in the House of Commons does not justify shutting down Parliament, again, taking away the ability of our representatives to do the work of the country. And I'll say one more thing, particularly so, right, in the face of President-elect Trump's recent announcements, the 25% tariff threat. We don't know if that's actually going to happen or not, but we have to take it seriously. There's also yesterday's comments. I understand they were a bit incendiary about using economic power and almost economic warfare to, get President Trump's policy goals met. Well, that's also something that ought to be taken seriously. Whether or not those things actually come to pass is speculation. Who knows? Our point would be Parliament has to be ready. Parliament has to be in session in order to deal with this stuff. I mean, what happens if President Trump wants to negotiate a different type of agreement with Canada in terms of border security or things like that? Somebody's going to have to be there to ratify an agreement. If it's an international treaty, Parliament will have to ratify them. And if Parliament's not there because they've been prorogued, how can that happen? The business of Parliament will not be able to happen, to function. So that's a real issue. And so, well, bottom line, it's an important case.
Well, and going on the Prime Minister's words, we covered the press conference, and then we went back over it with a fine-tooth comb and looked at what he said as well. And then we also looked back at some of the things that he had said on record back in 2020 when he was asked about proroguing at that point too. And his argument at that point was, well, we're just doing a reset. We're resetting the agenda. And he was actually trying to defend what he was doing in comparison to Stephen Harper. He's saying, well, we're proroguing Parliament, but we're coming back on the exact same day that we were supposed to come back in the first place. And this was in August of 2020 that he was saying this. Yet all of a sudden on Monday, he refers to the 2008 prorogation of Stephen Harper, and he says, no, the Governor General was completely correct in saying that was appropriate, and that, don't worry, we're only going to March. Okay, well, if your objective is just a reset, then you shouldn't need to go to March. You can reset the agenda, everything falls away, and you come back on the 27th anyway. So that shouldn't even matter. If all they're looking for a reset, there is no reason whatsoever, and this is no doubt in the core of the argument that you guys are making, to go to March 24th. There's it doesn't make sense. And in the words of Judge Judy, if it doesn't make sense, it's not true. So is indicting Trudeau's previous statements coming into play in this case, do you think?
It's important to remember that other instances of prorogation in the past aren't the issue. We're not here to relitigate those things. I was giving an interview this morning on a different show, and the interviewer asked me about the 2008 prorogation from Stephen Harper. And to be quite candid, I wasn't happy about that either, personally. Speaking legally, I don't know whether it was legal or not. I remember I don't think I was a lawyer at that point. If I was very, very new. But anyway, I remember that there was a coalition government back in 2008 that was trying to become the government by, overriding the minority government of Stephen Harper. And they went to Michaël-Jean, or Harper went to Michaël-Jean. It was all very, very confusing and very, very strange, as we all recall. But it was quite a tenuous coalition. You had the Bloc Québécois, a separatist party, involved with the NDP and the Liberals, I think it was. And there was really no guarantee that that coalition was going to hold together either. And so also, I think there had just been an election, and that had returned a minority. So the will of the people had been at least spoken a little bit. Secondly, my understanding, and don't quote me on this, but my understanding is that Governor General Jean at the time, she required that Prime Minister Harper come back from prorogation with a budget bill. And that was a money bill, a supply bill. So that was an automatic confidence vote that was going to be involved in that bill. So ultimately, Harper was going to face a confidence vote right away when he came back from prorogation. Right. So in that case, she, I think, exercised a little bit of her authority, shall we say, to make sure. She's like, well, I'm probably not very happy about this. Probably that's kind of what happened, but I'll let you do it grudgingly, but you got to make sure that this is what happens when you come back. Now, this is, again, a different situation. I don't know, frankly, if that was even okay back in 2008. We did not have the benefit of the UK's ruling in 2008. It just happened in 2019. If that had been the case, and if somebody had the creativity or the motivation to challenge Prime Minister Harper's decision back then, who knows what might have happened? We'll just never know. So to answer your question, I'm sorry I'm very long-winded. Those other instances of prorogation may or may not be relevant. I would probably argue they're not really relevant because they're always based on different things at different times, and it's always going to come down to the reasons given by the Prime Minister. And again, in this case, well, we have those reasons from Monday. And again, our view is that those are not sufficient. I think that, well, I'll leave it at that.
Well, and that's where it's going to be interesting, and I won't press you on this question because, again, this may be in your toolkit, it may not be. The fact that Justin Trudeau was defending his own prorogation back in 2020 by saying, well, we're not altering when we're coming back. We're coming back on the same day. We're just resetting the agenda. That's it. Yet you have 4 years later, all of the opposition parties have declared that they will be voting non-confidence at their first opportunity. Now it's, well, we're resetting Parliament, but I need an extra 2 months for some reason. And now we're not going to come back on the same day. Now that's not important to me. So it'll be interesting to see if that comes back to haunt him. As he probably lost all of his speaking notes as they all flew away right before his press conference. That may or may not have had something to do with it. But wanted to also circle back to this. There is no precedent in Canada for this, which is why you're having to use the UK decision. And this is an extremely important case. I imagine legal and constitutional scholars are really interested to see how this works out, because this is in fact going to create a brand new precedent in Canada, isn't it?
I think it will. I hope it will. I think we'll be inviting the court to do that. It's true. Some legal commentators or scholars may have their views about, how the case is framed, what we're asking the court to do, whether we're just going to be completely shut out from the court, whether they're going to even take our case or not. In some quarters, I've heard, people talk about the Governor General's decision to accept the Prime Minister's advice to prorogue, and whether the Governor General, being, of course, the King's representative, whether she has any residual power of her own to refuse the Prime Minister's, advice to prorogue. And I just want the viewers to understand, because I've heard a lot of this, particularly also during COVID. We all remember those dark days of COVID when many people were asking the Governor General to step in and do something and exercise her powers to stop this or whatever. We have to understand that that's not really a good idea, right? I mean, even though we may be unhappy with the Prime Minister of the day or whatever, that is not a reason to give power to an unelected person who has no accountability to anybody. That is giving power back to the King. I don't want to be a servant or a subject of the King in that way, right? So we need to have a democratic government. As much as some of us may at some point be unhappy with that, the way to go is not to ask the Governor General to step in and stop things. That would be, in my view, a constitutional disaster, because now who's actually in charge? Can the GG just say no at any point to anything? And I suppose the counterpoint to that argument would be, well, no, James, obviously there are going to be limits to what she can do. Okay, but now we're talking about, well, what are those limits, and when can she say no, and when does she have to say yes, and whatever. No, that's going to be a chaos. The best thing to do is to be the way it is, which is that the Governor General does whatever she's told to do by the Prime Minister. That is democratic government. We don't want to go back to the dark days of the kings and queens of England back in the day. That's not where we want to be. So whether or not we're happy with what the Prime Minister does is a different matter, of course, which can be solved through elections and through cases like this, because now we're talking about, hey, what are the limits of the Prime Minister's power to in this case, again, shut down Parliament for 3 months, almost 3 months. This case is interesting because, again, the power to do this, the Prime Minister's power, is a royal prerogative power. That's where it comes from. It comes from the power of the monarch to simply do whatever they want, and that's why it's such a I don't want to say dangerous power, but it's something that needs to be taken very seriously, because, again, this power doesn't appear to have limits, or does it? We think it should. And again, we're going to ask what they are.
So this court case is going to court now. How long is this going to take? Because the prorogation is set to be over on March the 24th. Do you guys expect that you'll have a ruling by then? What can Canadians expect?
Well, we have asked the federal court for an urgent hearing. I will give you guys actually a bit of a scoop right now. I just found out a few moments ago, before this interview started, that the federal court has asked us, the applicants' counsel, to either bring a motion in court to get an expedited hearing date, or consent from the Crown. So we're going to have to approach the Crown, the responding parties. So the lawyers will probably be coming from the Department of Justice in the federal government. Once we know who they are, because this is all happening very, 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 very fast, of course, we haven't even heard from our opponents yet. We haven't heard from our opposing counsel yet. So once they figure that out, we're going to have to see if they will agree to an expedited hearing. If they agree, then it looks like the court will grant that request. If not, we'll have to go to a formal motion in court, where we'll have to argue before a judicial officer, whether it's a judge or an associate judge, to ask for an urgent hearing. And then at that point, we will be explaining the reasons requiring an urgent hearing, and I think they're pretty obvious. So we'll have to see what happens. Assuming we get an urgent hearing, well, that would be as soon as the court can accommodate a hearing day. I don't think this is going to take a very long time to argue. I don't think we're talking about multiple days or anything, maybe a day in court if ever this came to a hearing. And so hopefully we could get this done well before the March 24th date. However, there's always the possibility that for some reason the court declines to give us an urgent hearing. That decision at first instance could be appealed like every other decision. That will be something we might have to contemplate. I don't know. But ultimately, if the case, let's say the case is ultimately heard in May, right? And Parliament's already come back on March 24th. Well, now there's the issue of mootness that would come up. And I know the viewers are probably already aware of that because mootness was a big issue in the COVID litigation that happened over the last few years. So the case will be, the issue, pardon me, will be whether the court should hear this issue, even though the issue is now no longer a live issue because Parliament came back. So there is a way, as I'm sure you guys know, to for the court to go ahead and hear the case anyway, even if it is moot, if the issues are important and compelling and Canadians need the answer. So we would say, even if there is a mootness issue on the table, that the issues raised are important enough that it ought to be heard anyway. We'll see what the court does with that, of course.
Yeah, even if it does take place, I think all Canadians deserve an answer as to what should those limits on prorogation powers be for the Prime Minister. For the exact point you raised before, what happens if Pierre Poilievre or a future Prime Minister chooses to make a questionable act of prorogation again? We need to have that answer so that if that does happen in the future, then we can make that argument. We'll see a lot of people, no doubt, pointing back to the Stephen Harper prorogation, saying, well, nobody challenged that, and why are you only challenging this? Well, nobody was there to challenge it. They could have challenged it. You can challenge any prorogation if you want. It doesn't mean that it's going to go forward. But now people know that you can challenge a prorogation, and if they wish to do that, they can approach organizations or legal counsel in the future and try to do that.
I agree.
So, in terms of the plaintiffs, who are the plaintiffs, James? Is it actual business people, or is it just ordinary Canadians?
We have two plaintiffs, and in this case, they are known as applicants because it's an application. It's not an action. That's just legalese. It doesn't really matter. But there are two applicants, and they're both citizens of Nova Scotia. So they live in Nova Scotia. One lives in Amherst. The other lives in near Halifax. And one is a doctor. He's actually a doctor and a lawyer together. And so he's obviously been to quite a lot of school. And the other is also he's also trained as a lawyer. So it's David McKinnon. He's the lawyer, and Aris Lavranos is the doctor-lawyer combination. So they're both just citizens of Canada. They're entitled to vote. They're very concerned about what's going on. And in our view anyway, that gives them standing. It gives them the ability to come to court and ask the court to grant them this remedy.
So here's the loaded question, one you'll probably not be able to answer. Do you think this will succeed?
I guess let me be blunt. I'm not in the habit of bringing cases that I don't think have a chance. Sometimes you might have cases come before the court that really shouldn't be before the court because they don't have a hope at all. of success. And those cases may be brought for ulterior motives. And that's something that I personally, as a lawyer, I take that very seriously. I would never do that. I would never take a case for a client if I didn't think there was an arguable case or that there was some value in doing it. And so there's going to be two parts to this, right? The first part is, again, what are the limits of a prime minister's power? That question is open-ended. We will ask the court to, again, adopt the UK decision, 100%. But if they don't, if the court doesn't want to go there and adopt that reasoning, they will have to say something about the prime minister's power, and then we will at least know more than we know now about what that power is. And so either way, win or lose, we'll have an answer. And I think in and of itself, there's intrinsic value in that exercise. That's the first thing. The second thing, of course, is more, I think, what you're driving at, which is, did the prime minister overstep or not on Monday? I think that if the court here in Canada is prepared to accept the reasoning of the UK Supreme Court, then we have a good case. We have a decent argument. We don't have a zero chance. I don't know what the percentage would be. No lawyer would ever say there's a 100% chance of winning. It's impossible. Any lawyer who says that should turn in their lawyer card immediately, because you can never guarantee what's going to happen in a lawsuit. But I can say that, again, if the issue is reasonable justification, well, I've laid out for you the arguments. We're going to say that, having a leadership race doesn't meet the cut. And 11 weeks of prorogation for a simple temperature lowering exercise doesn't make the cut either. So we'll see what happens. Now, naturally, of course, there's always the possibility of an appeal from the lower court. This will eventually get before a judge of the federal court. That's the lowest level of the federal court. And then from that, there's the Federal Court of Appeal, and then there's the Supreme Court of Canada. There is a way, very, very rarely done, I'm not sure if it's even ever been done, but there is a way to leapfrog over the Federal Court of Appeal directly to the Supreme Court of Canada. Everybody has to kind of agree to do that, including the Supreme Court. So it's not something that happens hardly ever, if ever. But there is a way to do it. Given the timelines, I don't know if that's something that might want to be entertained. We'd have to wait and see what the decision that comes looks like, and whether there's any reason to consider an appeal anyway. These are all things that have to happen in the fullness of time, of course.
Well, and it sounds like that's probably what happened in the UK case, because yes. I think they were able to deal with that very quickly, and it ended up in the Supreme Court very quickly. So
yeah, there was some similar mechanism there that allowed them to go to the Supreme Court right away. That's right.
Right. So hopefully this the assumption that everyone will give this its due diligence and its due attention. I think the only way that this can cause a lot of problems is if the courts just decide, no, the prime minister has absolute power to decide when to prorogue. I think that would be a very dangerous precedent, and then there would be an appeal on that decision up to the next line of court as well. Is that fair?
Yeah. So I mean, we have to understand as well that it would be possible for that to change, even if that's the way that the court comes down. If the court says, no, the prime minister has the unlimited power to prorogue parliament for as long as she likes, no matter when or where or whatever. And there's only one escape hatch, which is that the Constitution says that parliament has to sit at least once a year. That's in the Constitution. And so as long as that happens once, the prime minister can prorogue parliament for the other 364 days if she wants. Well, I would argue that that can't be right. But if that's the way the court comes down, hypothetically, it would be open to Parliament to change that.
Yeah.
Parliament could pass a law to say that like the Prorogation Act, and and Parliament could say that here are the rules that the Prime Minister must follow when proroguing, and that would supersede the common law decisions set down by this court. Another way that might need to happen would be they might need to change the Constitution or add a provision to the Constitution, which would involve amending the Constitution. That's not an easy thing to do, but something as serious as this, you might actually get buy-in from the provinces to actually amend the Constitution to circumscribe the powers of the Prime Minister. If the court comes down and says, no, it's unlimited, there's no limit to what the Prime Minister can do, I don't think Danielle Smith, for example, would really go for that, for example. So there may be buy-in from the premiers at that point to amend the Constitution to change that. So, and if that's the case, then of course, the decision coming from the courts, hypothetically, would be overturned.
Well, this has been very enlightening. Thank you so much for the detail, James. On behalf of Canadians, I think on both sides of the aisle, thank you for taking on this case, because whether or not you support what Justin Trudeau did or not, I think it's important for all of us in Canada to understand what the limits of the Prime Minister's power when it comes to prorogation is, because it's going to apply to governments for generations to come, and we need an answer to that. So thank you for taking this on, and we will be watching with great interest and keeping Canadians informed. And on behalf of everybody here, good luck with the case.
Well, thank you so much. Thanks for having me.